All right, Tuesday. The former United States Attorney General walked into federal court. Audio tape, 47 minutes, according to court documents filed yesterday. It's devastating. The judge stopped proceedings, demanded answers. Right there, I've been going through the transcript and emergency motion. 89 pages dropped Thursday night. Here's what happened. Pam Bondi, U.S. Attorney General until April, just became the government star witness against Trump. The tape, Trump's voice, her voice, her voice, discussing what the filing calls obstruction of federal investigations while she led the Department of Justice. Quote from page 12. The former Attorney General's recordings capture the defendant directing interference with active DOJ cases. That's the court, not me. Let me show you quick context. Pam Bondi, United States Attorney General, resigned April 2026, ran DOJ for Trump. The issue, 2 months after leaving, she flipped, granted immunity, brought recordings from inside the Justice Department. Timeline fast version. Weeks back, special counsel investigation into campaign finance violations accelerates. Grand jury expands in Atlanta. Days later, subpoenas issued. 17 former officials. Bondi gets one. 2 weeks after that, Bondi's attorneys approach special counsel. They have something nobody expected. That's the setup. Now, the documents. The case centers on allegations Trump directed a $8 million scheme through shell companies in Nevada, Delaware, and Wyoming. Money allegedly funneled to state officials during 2024 election challenges. Bondi's name appeared on 31 emails recovered from DOJ servers. She wasn't charged initially. She was referenced. Then her legal team revealed she'd been recording conversations with Trump while serving as Attorney General. Recordings made inside the White House, inside DOJ headquarters, on secure phone lines. Special counsel offered complete immunity Wednesday morning. She accepted. Tuesday afternoon, audio played in federal court. Former U.S. Attorney General testifying against the president who appointed her. That's where this detonates. Okay. The evidence. First document filed Thursday. I pulled page 34. It says, quoting here, former Attorney General Bondi provided authenticated recordings of 9 telephone conversations with the defendant made between December 2024 and March 2026. That's not my take. That's the filing. What it means, she recorded the president while running his Justice Department. But here's what got me. Page 51, different section. Transcript of call 4, January 23rd, 2025, 9:14 p.m. from her DOJ office. Trump's voice, according to official court transcript. You're my Attorney General. You can make this Georgia thing go away. That's why I put you there. Bondi's response. Sir, I can't interfere with an active special counsel investigation. Trump, yes, you can. You're in charge. I need you to be a team player here. Put those together. Yeah, that's obstruction from the president to his Attorney General. I went through this twice. Patterns clear, call 2. Trump asks Bondi to slow down the Atlanta grand jury. Call 5. Trump references $840,000 payment to a Nevada LLC. Says your office doesn't need to look at that. Call 7. Trump explicitly says this stays between us. No memos. All documented, all time-stamped, all played in open court Tuesday. Now, what nobody's covering, the forensic analysis attached as Exhibit D. Audio expert, former NSA technical specialist, 22 years experience, examined every file, found 0 evidence of manipulation. His conclusion, page 67, recordings were made on a government-issued secure device. Metadata confirms dates, times, and device identity. Files are authentic. Read that again. This changes everything. The defense argued deep fakes, AI manipulation, fabricated evidence. This destroys that defense completely. These recordings were made on DOJ equipment, logged on government servers, backed up automatically. Chain of custody is ironclad. Fallout. Trump's legal team filed emergency motion to exclude. Denied within 4 hours. 5 co-defendants immediately began cooperation discussions. Special counsel confirms 3 are in advanced negotiations. The judge ordered Trump to produce all communications with Bondi from her entire tenure as Attorney General within 72 hours. But okay, here's the thing. Page 14 reveals Bondi's immunity is comprehensive. Covers everything she did as AG, not just cooperation. Full protection from prosecution, which means she had exposure, real exposure. According to partially unsealed filing from Thursday, she sat for 14 hours of depositions, named 11 individuals, including sitting cabinet members. The filing notes. Former AG Bondi provided documentary evidence, including internal DOJ memos, text messages with White House staff, and financial records showing $3 million in transfers she was directed to ignore. That's new money, different from the original $4, $8 million. Scope just doubled. Here's what else. The judge's statement from the bench Tuesday, page 23 of transcript. In 23 years on the federal bench, I have never seen evidence of this magnitude. A former attorney general under oath providing recordings of a sitting president directing her to obstruct justice. This court takes that with utmost seriousness. Courtroom went silent. Not just evidence, historic evidence. And it came from Trump's own attorney general, the person who controlled federal law enforcement. That's just the first document. Subscribe. I'm not done. 4 more filings dropped overnight. I'm breaking them down now. You'll want this analysis when it's ready, okay? But look, got to be fair here. The other side has a point. Few points, actually. Trump defenders say this is the deep state's ultimate betrayal, a weaponized attorney general who turned on her own president. And honestly, some of it holds up their argument. First, Bondi ran DOJ. She had power to resist if Trump crossed lines. Instead, she recorded him secretly while pretending to be loyal. That's not whistleblowing, they say. That's entrapment. Second, she kept her job for months while gathering evidence, took a government paycheck, directed DOJ policy, all while building a case against her boss. Ethics of that are complicated. Former Trump advisor Stephen Miller put it this way. She's a traitor who stabbed the president in the back while running his Justice Department. Don't agree with all of it, but that's not nothing. What they've got. Bondi had a legal obligation as AG. If Trump committed crimes in her presence, she should have reported immediately, not record secretly for months. The timing of her resignation in April, followed by a deal in June, looks coordinated like she planned her exit strategy. Even legal analyst Jonathan Turley admits recording your boss, the president, while serving as AG raises profound constitutional questions about executive privilege. Look, I'm not here to tell you who's right. Prosecution's interpretation, Bondi tried to resist internally. When that failed, she preserved evidence, then removed herself and came forward. Defense interpretation, she's a deep state operative who infiltrated DOJ specifically to take down Trump. The recordings are selective. Context is missing. Both can be true. That's what makes this complicated. Trump supporters make another argument worth considering. The conversations on tape. They say it's normal president-to-cabinet communication. Trump expressing frustration, venting, not ordering crimes. Constitutional law professor at Harvard, sympathetic to executive power arguments. Presidents talk to their AGs about politically sensitive cases all the time. The line between improper and illegal is unclear. There's truth there. The defense filing argues extensively. These recordings capture privileged executive communications. The president has Article 2 authority to discuss DOJ matters with his attorney general. They point to specific phrases. Make this go away could mean handle it properly, not obstruct it. Be a team player could mean follow administration priorities, not break the law. Vague language subject to interpretation. Trump's attorneys also note, if Bondi thought crimes were happening, why stay as AG? Why not resign immediately? They argue her continued service proves she didn't believe anything illegal occurred. The criminal interpretation came later after she got her own subpoena. That's strategic framing, they say, not truth. And look, there's logic there. What I can tell you what the documents show. They show 9 recorded conversations. A former attorney general under oath saying Trump directed her to interfere with investigations. Whether that's obstruction or executive management, that's for a jury. But the evidence is now in the record. This didn't come out of nowhere. Backstory quick. Years back, Bondi, Florida attorney general, becomes Trump ally, defends him publicly, gets appointed to transition team. Later, brings her into second-term administration, makes her attorney general. She's his 4th AG, chosen specifically for loyalty. First few months, she functions as expected, defends Trump administration in court, pushes his DOJ priorities. Then, special counsel investigation heats up. Grand jury in Atlanta, campaign finance allegations, Trump's circle getting subpoenaed. Someone even said on record, a former White House counsel, Pam was hired to protect the president. Everyone knew that was her job. What happened? The pressure became unbearable. Pattern. According to Thursday's filing, Trump began calling Bondi directly about pending cases weekly. At first, calls escalated to demands. Shut this down. Fire that prosecutor. Bondi started documenting. First just notes, then recordings. She later told investigators, "I realized what he was asking me to do was illegal. I needed proof. Every time before Trump's AGs either complied or resigned." Sessions recused himself, fired. Barr pushed back, eventually left. Bondi did something different. She stayed and recorded until April 2026, resigned abruptly. Personal reasons. 2 months later, immunity deal, recordings, testimony, and Tuesday in federal court in Atlanta, those recordings played. Trump heard his own voice giving orders to his attorney general. Orders she's now saying were crimes. Like, if it makes sense so far, this is the biggest political legal case in modern history. Multiple layers. The breakdown matters. One click helps this reach people who need the full context. Tuesday, 2:14 p.m. Here's what happened. The prosecutor pressed play. Trump's voice filled the courtroom. "You're my attorney general. You can make this Georgia thing go away." Room went dead silent. What followed? 47 minutes of audio, 9 separate conversations. Trump's attorneys objected 6 times, overruled every time. Multiple reporters noted Trump's jaw clenched, eyes forward, didn't move. 18 minutes in, that fast, the judge stopped playback. Counsel approached the bench now, sealed conversation. 8 minutes. When Trump's lead attorney returned, visibly shaken, loosened his tie. Now, what everyone missed. While people focused on Trump's reaction, something else happened. 6 people in the gallery stood up simultaneously, left together, later identified as current DOJ officials still serving. They didn't return. Then, prosecutors exchanged notes. Urgent. The judge's response? Unscheduled recess immediately. Wasn't reactive, calculated. You can see it in Wednesday's transcript, page 178. During recess, special counsel met with 4 additional witnesses, emergency proffer sessions in courthouse conference rooms. The recordings triggered something. New cooperation. By Tuesday, end of day, the witness list expanded. 7 new names. Thursday's filing confirms the government anticipates testimony from current and former DOJ personnel whose knowledge became relevant following evidence introduced June 16th. Translation: the tapes exposed other crimes, other witnesses. Here's where it gets interesting. 1 new witness, current Deputy Attorney General, Bondi's second in command, still serving, now cooperating with investigation into her former boss. The audio didn't just damage Trump, it implicated an entire chain of command. The judge's order Thursday night, all parties shall preserve communications with the following 19 individuals effective immediately. That list includes 3 current cabinet members, 5 former White House counsels, 2 sitting senators. The scope isn't narrowing, it's metastasizing, and it started with 47 minutes of a former attorney general's recordings played in open court Tuesday afternoon. Don't go anywhere. What I show next changes the picture. This isn't just criminal charges. This is constitutional crisis territory. Next section explains why that matters for everyone. What are experts saying? Former Deputy Attorney General, 12 years at DOJ under 3 administrations. An Attorney General recording the president is unprecedented. The evidence is explosive, but the method raises concerns. Plain English, the recordings are damning, but how they were obtained complicates everything. Another one, former federal prosecutor, Southern District of New York. Audio of a president directing his AG to obstruct justice. If authenticated, that's case over. Key there, this is the clearest evidence possible of corrupt intent. Here's what's interesting. Even a defense-oriented legal analyst admits you can't cross-examine a recording. If that's Trump's voice saying those words, the defense is in serious trouble. When both sides agree, pay attention. Constitutional law professor at Yale. This creates tension between criminal accountability and executive privilege. The recordings may be evidence of crimes, but they're also privileged executive communications. That matters. Trump's team will argue executive privilege shields these conversations. Courts will have to decide if privilege covers criminal activity. Former Solicitor General. The president has no privilege to direct his attorney general to commit crimes. These recordings should be admissible. Translation: criminal conspiracy exception to privilege. Another former DOJ official, white-collar crime division chief, 5 co-defendants negotiating after hearing these tapes tells you everything. They know Trump's own words convicted him. Here's the consensus. The recordings are likely admissible despite privilege claims. Crime fraud exception applies. Bondi's credibility will be attacked, but the audio speaks for itself. This is the strongest evidence in any Trump prosecution to date. His own voice giving orders to his attorney general. former U.S. attorney, 19 years experience. I've prosecuted mafia bosses, cartel leaders, corrupt politicians. This evidence is better than anything I ever had. That's where professionals land. Not a guaranteed conviction, but the closest thing to it. Useful breakdown. Like it. I'm monitoring every filing in real time. This case is moving fast. The algorithm pushes content that gets engagement. Help this reach people. 1 second. Why should you care? Real talk. How this affects actual people. This sets a precedent. Cabinet members recording the president using government devices as insurance. Next administration, every conversation is potentially on tape. That changes governance entirely. President can't trust cabinet. Cabinet can't trust president. Is that accountability or paralysis? Not dramatic. That's the reality this creates. Right now, 19 individuals under preservation orders, current government officials, sitting cabinet members hiring criminal defense attorneys. That's confirmed. Their careers, their freedom, their reputations, all at risk because of conversations they had with Trump or Bondi. These are people still showing up to work, still running agencies while under federal investigation. Uncomfortable part. If you work in federal government, any level, your communications aren't safe. Your boss might be recording. Your subordinates might be recording. One subpoena later, everything you said in confidence becomes evidence. If you've ever worked for a political appointee, you're vulnerable. Not trying to scare you. That's what this case teaches. Every email, every call, every meeting, potentially discoverable, potentially criminal. Next time you vote or pay taxes, understand this. Your elected officials can't function if they're constantly recording each other. Policy discussions require candor. Strategy requires confidentiality. Bondi's recordings might bring Trump to justice, but they also poison executive branch operations. Future presidents will be paranoid justifiably. Is that better democracy or just different dysfunction? If you ever end up in court, any case, this is the new standard. Record everything. Protect yourself. Document every conversation because the person you trust today might be wearing a wire tomorrow. Bondi was Trump's loyalist, his chosen attorney general. 2 months after resigning, she's the star witness against him. If that can happen at the highest levels of government, it can happen anywhere. This creates a crisis over executive privilege. Does a president have the right to speak candidly with his attorney general? If those conversations can be recorded and used against him, how does executive branch function? Might be guilty, and these recordings might prove it. But the method, a cabinet member secretly recording the president, that's a weapon that can't be uninvented. Next president, different party, same vulnerability. What informed people doing? Government officials reviewing their communication practices. In-person meetings only. No phones present. Political appointees documenting everything they're asked to do, creating paper trails. Question to ask if you work in politics: who in this room might one day need immunity? Sounds paranoid, but Bondi was Trump's handpicked AG. If she flipped, anyone can. Knowledge helps. How'd Trump respond? Made it worse. Honestly posted within 2 hours of court adjourning Tuesday. Quote, Pam Bondi is a traitor who committed treason by recording the president. She should be prosecuted. Reaction? Legal experts noted calling for prosecution of a witness is potential intimidation. Special counsel filed motion Wednesday requesting judicial intervention. His attorneys issued a statement Thursday. The defendant maintains absolute innocence. These recordings were illegally obtained and violate executive privilege. Then Wednesday night, Trump held a rally called Bondi the worst attorney general in history and a deep state plant. Said, quote, she was never loyal. She was always working against me. Everyone will see. The judge responded Thursday afternoon. 3-page order. The defendant is hereby reminded that witness intimidation, threats, or harassment violates the conditions of pretrial release and federal law. Translation. Stop now. Trump's team requested gag order on Bondi instead. Argued she's doing interviews, so he should respond. Special counsel opposed hard. Their filing, the defendant seeks to silence the witness whose testimony he fears most. The court should reject this transparent intimidation tactic. Judge hasn't ruled yet. But Thursday night, Trump posted again, I have the right to defend myself against lying witnesses. His attorneys are reportedly pleading with him to stop. He's not listening. Every post creates new evidence of witness tampering, not cooling down, escalating. What's still unclear? 1, how many more recordings exist? Bondi provided 9 calls. The immunity agreement mentions additional materials currently under review by the special counsel. Could be more tapes, could be documents, nobody knows. 2, who else recorded Trump? If his attorney general did, what about his chief of staff, his advisors? 3, what current officials knew? The deputy AG is cooperating now. What did he know while serving under Bondi? Coming status conference scheduled Monday, June 22nd. Both sides must provide updated witness and exhibit lists. Trump's team preparing motion to dismiss based on executive privilege. Wants all recordings excluded. Special counsel preparing opposition. Arguments due Tuesday. Date to watch Wednesday, June 24th. Deadline for Trump to produce all communications with Bondi during her tenure as AG. Could be thousands of pages. Emails, memos, texts. If anything contradicts his current defense, prosecutors will use it. Also coming, Bondi's public testimony. Preliminary hearings scheduled July 8th. She'll be under oath, cross-examined publicly. That's when we see if she holds up under pressure. Should know more soon. Subscribe. I'll cover the update when it drops. Monday's conference could shift everything. Wednesday's document production might reveal new evidence. I'll break it down when it happens. Where we are right now. 9 audio recordings admitted as evidence. All privilege challenges denied. Former U.S. Attorney General Pam Bondi granted full immunity, fully cooperating. 5 co-defendants in active plea negotiations. 3 in advanced talks. Trump under judicial warning about witness intimidation, posting anyway. Witness list expanded to include current DOJ officials and sitting cabinet members. Scheduled Monday, June 22nd, status conference. Court receives updates on trial timeline. Tuesday, June 23rd, Trump's executive privilege motion due. Wednesday, June 24th, deadline for Trump's team to produce all Bondi communications from her AG tenure. Friday, June 26th, special counsel's response to privilege motion due. Not public yet, content of recordings 5, 6, and 8. Transcripts exist in sealed filings. Prosecutors say they're more damaging than what's been disclosed. Judge will decide later this month whether those stay sealed. Also unclear whether Bondi recorded other officials. Her immunity agreement covers any and all evidence provided regardless of source or subject. That language suggests more might exist. Trial currently scheduled for October, but with expanding cooperation and new evidence, expect delays. Clock's running, developing daily. That's where we are. Trump facing recordings of his own voice directing his attorney general to obstruct federal investigations. Surface read, devastating evidence, historic betrayal, unprecedented case. But executive privilege questions remain unresolved. Bondi's methods will be challenged. This goes to trial. Anything can happen. What I'm watching, the co-defendant negotiations. If 3 more flip with their own recordings, this becomes a pattern, not isolated incidents. That changes everything for Trump's defense. I'm also watching the current DOJ officials now cooperating. If people still in government are testifying against Trump, that's the deep state narrative coming true. Or career officials choosing country over party, depending on your perspective. The judge's patience with Trump is nearly gone. One more threatening post about Bondi, we could see detention motions. Rare, but possible. Story's not over, still unfolding. Documents drop constantly. New filings every day. Wednesday's production will be massive. I'll go through it. When Bondi testifies in July, I'll break down every word. Subscribe for the full picture, not just headlines. This case will define presidential accountability for generations. I'm covering all of it. Let me tell you why this matters beyond the courtroom. You need to understand what's really happening here. This isn't just about Trump. It's not even just about Bondi. This is about the entire structure of American governance and how power works at the highest levels. What we're watching is the collision of 2 fundamental principles that have always coexisted uneasily: executive authority and criminal accountability. The president has always had broad powers over the Justice Department. The Attorney General serves at his pleasure. But there have always been limits. The question is where those limits are and who gets to enforce them. Bondi's recordings don't just prove obstruction. They prove that Trump knew exactly where the line was and deliberately crossed it. Because he didn't just ask her to do something questionable. He insisted, he demanded. He made it clear that loyalty to him was more important than loyalty to the law. That's what the tapes show, and that's why they're so devastating. But here's the part that should concern everyone, regardless of politics. The method Bondi used is now a template. Any attorney general, any cabinet member, any official with access to the president can do what she did. Record everything, wait for the right moment, then use it. That changes the fundamental nature of executive branch operations. No president can speak candidly if every conversation is potentially recorded. No advisor can give honest counsel if their words might later be used against them. The chilling effect on governance is real and it's permanent. Once this precedent is established, it can't be undone. Future presidents will operate in a fog of suspicion. They'll communicate through intermediaries. They'll avoid putting anything in writing. They'll restrict access and limit discussions. That's not how effective government works. That's how paranoid government works. And we're all going to live with the consequences. So when you watch this case unfold, remember, it's not just about Trump's legal exposure. It's about the future of the presidency itself. The recordings are evidence of crimes, but they're also evidence of a system breaking down. Trust is gone. Loyalty is transactional. Everyone is protecting themselves first. That's not a healthy democracy. That's a system in crisis. And the crisis didn't start with Bondi. It started when presidents began treating the Justice Department as a personal legal defense firm. It started when attorney generals began seeing themselves as political protectors rather than public servants. Bondi's tapes are the logical endpoint of that trajectory. She was chosen for loyalty, she was expected to protect, and when the pressure became too much, she protected herself. That's the system working exactly as designed. The problem is the design. And now we're all paying the price. Let me break down the legal strategy here because it's fascinating and tells you everything about how this case is going to play out. The special counsel is pursuing a classic prosecution approach. Build the case from the bottom up. Start with the co-defendants, flip them with immunity deals, get them to testify, use their testimony to pressure the next level, and keep climbing until you reach the top. Bondi is the crown jewel of that strategy. She's not just a witness. She's the witness. She was in the room. She was on the phone. She has the recordings. There's no one who can contradict her except Trump himself, and he can't testify because he'd incriminate himself. So the defense is left with attacking her credibility, questioning her motives, arguing executive privilege. None of that works against a recording. You can attack the witness. But the audio speaks for itself. That's why Trump's legal team is so desperate to get the recordings excluded. They know that if the jury hears those tapes, the case is effectively over. And here's the thing, the law is clear on this. The crime fraud exception to executive privilege means that privileged communications lose protection if they're made in furtherance of a crime. So Trump can claim executive privilege all he wants, but the judge is going to look at the transcripts and say, these conversations were about obstructing justice. That's not privilege. That's evidence of a crime. And the evidence is going to come in. I've seen this play out before. I've watched defendants try to hide behind privilege when the evidence is clear. It never works. The judge sees the pattern. The lawyer makes the argument. The judge rules against them. And then the evidence comes in and the jury convicts. That's what's going to happen here, barring something completely unexpected. But let me be honest with you about something. There's a scenario where this doesn't go to trial. And I'm not talking about a plea deal. I'm talking about something else entirely. If enough co-defendants flip, if the evidence becomes so overwhelming that Trump's attorneys advise him to cut a deal, there's a possibility this never sees a jury. Now, a deal would be unprecedented. A former president pleading guilty to obstruction charges. That's history. That changes everything. But it's possible. The legal exposure is real. The evidence is strong, and Trump's attorneys are pragmatic. They're not going to let him go to trial if they know he'll lose. They'll try to negotiate something that preserves his freedom and limits the damage. Of course, Trump himself might not go along with that. He's never been one to admit defeat. He's never been one to plead guilty. He fights everything. And that's why this is probably going to trial. He'll take his chances with the jury. He'll hope for a hung jury. He'll hope for an appellate court to save him. He'll hope for anything except accepting responsibility. That's who he is. That's how he's always operated. And that's why this case is going to be the defining moment of his legal career. One way or another, this ends in a courtroom. And the recordings are going to be the centerpiece of the prosecution's case. So let me tell you what I'm watching for in the coming weeks. First, the document production. Wednesday's deadline is huge. Trump's team has to produce everything, and I mean everything. Emails, memos, text messages, phone records, meeting notes. Anything that relates to Bondi or the obstruction allegations. If there's anything in those documents that contradicts his defense, it will come out. Second, the plea negotiations. If 3 more co-defendants flip, that's a game changer because they'll have their own evidence, their own emails, their own testimony, their own recordings potentially. And each flip makes the next one easier. The dominoes start falling and they don't stop. Third, the judge's rulings. The executive privilege motion is going to be telling. If the judge rules against Trump, and I expect she will, that's a signal that this case is going to trial and the evidence is going to come in. If she rules in his favor, that's a stay of execution. But I don't think that's going to happen. The law is clear. The crime fraud exception applies. The recordings come in. Fourth, Bondi's testimony. The preliminary hearing in July is going to be explosive. She's going to be under oath, cross-examined by Trump's attorneys, forced to defend her actions. Will she hold up? I think she will. She's been preparing for months. She has immunity. She has nothing to lose. And she has the recordings to back her up. The cross-examination is going to be brutal, but she's ready. She knew what she was doing when she made those recordings. She knew she was building a case. She knew she was protecting herself. She's not naive. She's a former attorney general. She understands the law. She understands evidence. She understands how this works. And she's going to be a devastating witness. So here's where we stand. 9 recordings, 5 co-defendants negotiating, 19 individuals under preservation orders, a judge who has already ruled against Trump multiple times, prosecutor with a mountain of evidence, and a former attorney general who is ready to testify. That's the picture. That's where this case is going. And I'm going to be covering every single development. But I want to be clear about something. I know there are people out there who think this is all political. I know there are people who think it's a deep state conspiracy. I know there are people who think Bondi is a traitor, and you're entitled to your opinion. But the evidence is the evidence. The recordings are the recordings. And no amount of spin changes what's on those tapes. Trump's voice, his words, his instructions, his demands, his pressure, his obstruction. All captured, all documented, all authenticated, all coming into evidence. That's not political. That's factual. That's what the court is going to hear. And that's what the jury is going to decide. So watch this space. Watch the filings. Watch the hearings. Watch the testimony. This case is going to define not just Trump's legacy, but the future of presidential accountability. And I'm going to be here breaking it down every step of the way. Subscribe, hit the bell, and make sure you don't miss any of it, because this is history. This is happening right now. And you need to understand what's really going on. I'll see you in the next update.